The Senate will come to order. Senator Kerr, would you please lead us in the pledge?
Thank you, Madam President. Would my colleagues and our guest in the chambers please rise and join me for the pledge? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Mr. Majors, would you please take the roll?
Aguilar. Aguilar.
Absent.
Balmer. Baumgartner. Brophy. Cadman. Crowder. Grantham. Guzman. Harvey. Heath. Herpin. Hill. Hill.
Absent.
Hall. Hodge, John, Johnston, Jones, Cafalas, Kerr, King, Lambert, Lundberg, Marble, Newell, Nicholson, Renfro, Rivera, Roberts, Scheffel, Schwartz, Stedman, Tocktrop, Todd, Uleberry, Zenzinger, Aguilar, Madam President.
Here. Senator Aguilar has been added to the roll call. Motion to adopt the journal. Senator Rivera.
Thank you, Madam President. I move that the reading of the journal from April 21st be dispensed with and the journal be approved as corrected by the Secretary.
You've heard the motion. All in favor say aye. Aye. Opposed, no. Ayes have it. That motion is adopted. Committee reports.
April 21st, 2014, Committee on Judiciary. After consideration on the merits, the committee recommends the following. House Bill 1273 be referred favorably to the Committee on Appropriations. April 21st, 2014, Committee on Judiciary. After consideration on the merits, the committee recommends the following. House Bill 1347 be referred to the Committee of the Whole with favorable recommendation and with the recommendation that it be placed on the consent calendar. April 21st, 2014, Committee on Judiciary. After consideration on the merits, the committee recommends the following. House Bill 1095 be referred favorably to the Committee on Appropriations. April 21st, 2014, Committee on Judiciary. After consideration on the merits, the committee recommends the following. Senate Bill 190 be amended as follows and as so amended be referred to the Committee on Finance with favorable recommendation. April 21st, 2014, Committee on Judiciary. After consideration on the merits, the committee recommends the following. Senate Bill 118 be amended as follows and as so amended be referred to the Committee of the Whole with favorable recommendation. April 21st, 2014, Committee on Judiciary. After consideration of the merits, committee recommends the following. House Bill 1162 be referred favorably to the Committee on Appropriations. April 21st, 2014, Madam President, the Committee on Business, Labor, and Technology has had under consideration and has had a hearing on the following appointments and recommends that the appointments be placed on the consent calendar and confirmed. Members of the Colorado Banking Board for terms expiring July 1st, 2017. John R. Dye of Denver, Colorado, representative of a money transmitter organization licensed pursuant to Article 52 of Title 12, appointed. James L. Basie of Denver, Colorado, serves as an executive officer of a state bank with not less than 5 years practical experience as an active executive officer of a bank, reappointed. Emily S. Robinson of Golden, Colorado, executive officer of a state bank with not less than 5 years practical experience as an active executive officer of a bank, reappointed. April 21st, 2014, Committee on Business, Labor, Technology. After consideration of the Mayor's Committee recommends the following. Senate Resolution 3 be amended as follows and as so amended be referred out to the Senate for final action. April 21st, 2014, Committee on Business, Labor, Technology. After consideration of the Mayor's Committee recommends the following. House Bill 1344 be referred to the Committee of the Whole with favorable recommendation with the recommendation be placed on the consent calendar. April 21st, 2014, Committee on Business, Labor, and Technology. After consideration of the Mayor's Committee recommends the following. House Bill 1199 be referred favorably to the Committee on Appropriations. April 21st, 2014, Committee on State Veterans and Military Affairs. After consideration of the Mayor's Committee recommends the following. House Bill 1331 be referred favorably to the Committee on Appropriations. April 21st, 2014, Committee on State Veterans and Military Affairs. After consideration of the Mayor's Committee recommends the following. House Bill 1330 be referred to the Committee of the Whole with favorable recommendation. April 21st, 2014, Committee on State Veterans and Military Affairs. After consideration of the Mayor's Committee recommends the following. House Bill 1329 be referred favorably to the Committee on Appropriations. April 21st, 2014, Committee on State Veterans and Military Affairs. After consideration of the Mayor's Committee recommends the following. House Bill 1328 be referred favorably to the Committee on Appropriations. April 21st, 2014, Committee on State Veterans and Military Affairs. After consideration of the Mayor's Committee recommends the following. House Bill 1327 be amended as follows and as so amended before the Committee on Appropriations with favorable recommendation.
Senate Services.
April 22nd, 2014, correctly printed, Senate Bill 208, Senate Joint Memorial 6, Senate Joint Resolutions 34, 35, and 36, correctly engrossed, Senate Bills 12, 14, and 162, correctly re-engrossed, Senate Bills 181, 183, and 189, correctly revised, House Bills 1313, House Joint Memorial 1001, correctly re-revised, House Bills 1003, 1006, 1034, 1042, 1045, 1181, 1185, 1203, 1207, 1228, 1284, 1321, and 1339.
Is there a place where that fits?
We could do it right now if you.
Third reading of bills, consent calendar. Please add Senator Hill to the roll. Mr. Majority Leader.
Thank you, Madam President. I've been requested to move House Bill 1313 from the consent calendar and be placed at the end of third reading of bills, final passage.
House Bill 1313 is removed from third reading consent and placed at the end of third reading calendar. Mr. Majors, would you please read the remaining bill on third reading consent?
Senate Bill 162 by Senator Nicholson and Representative Mitch Bush concerning quality management programs for emergency medical service providers providing care in the pre-hospital setting.
Mr. Majority Leader.
Thank you, Madam President. I move the adoption of Senate Bill 162 on third reading of bills consent calendar.
Any discussion? Question is the adoption of 162. Are there any no votes? With 35 ayes, 0 noes, 0 absent, 0 excused, Senate Bill 162 is adopted. Co-sponsors. Senators Aguilar, Newell. Third reading of bills. Mr. Majors, would you please read the title to Senate Bill 12?
Senate Bill 12 by Senator Kafalas and Representative Exum concerning increasing the assistance payment for the program for the aid to the needy disabled and in connection therewith making and reducing appropriations.
Senator Kafalas.
Thank you, Madam President. Good morning, colleagues. I move Senate Bill 12 on third reading and final passage and respectfully ask for a yes vote.
Any discussion? Question is the adoption of Senate Bill 12. Are there any no votes? Senators Renfro, Crowder. Mr. Minority Leader, Senators Shuffle, Baumgartner, Harvey, Lambert, Brophy, Marble, Herpin, Grantham, Hill, Balmer. With 22 ayes, 13 noes, 0 absent, 0 excused, Senate Bill 12 is adopted. Co-sponsors. Mr. Majority Leader, Senators Aguilar, Kerr, Ulibarri, Zenzinger, Newell, Todd, Jones, Nicholson, Talktrop, Todd. Please add the President. Senator Schwartz is a co-sponsor. Mr. Majors, would you please read the title to Senate Bill 14?
Senate Bill 14 by Senator Kafalas and Representative Pedersen concerning the property-related expense assistance grants for low-income seniors and individuals with disabilities and in connection therewith making and reducing appropriations.
Senator Kafalas.
Thank you once again, Madam President. I move Senate Bill 14 on third reading and final passage, and once again, I respectfully ask for a yes vote.
Any discussion? Question is the adoption of Senate Bill 14. Are there any no votes? Senator Lundberg, Senators Baumgartner, Marble, Grantham, Brophy, Balmer, King, Hill, Harvey, Lambert, Shuffle, Mr. Minority Leader, Senators Shuffle, Herpin. Senator Renfro, I've got you. With 21 ayes, 14 noes, 0 absent, and 0 excused, Senate Bill 14 is adopted. Co-sponsors, Senators Ulibarri, Aguilar, Mr. Majority Leader, Madam President Pro Tem, Senators Nicholson, Newell, Stedman, Kerr, Hodge, Todd, Zenzinger, Jones, Johnston, Schwartz, Talktrop. Please add the President. General orders, second reading of bills. Yes, we moved that one. My apologies. Mr. Majors, would you please read the title to House Bill 1313?
House Bill 1313 by Representative McLaughlin and Senator Nicholson concerning a requirement that the owner of a pet animal provide a valid rabies vaccination certificate prior to registering the animal with the county.
Senator Nicholson.
Thank you, Madam President. I move House Bill 1313 and on third reading and ask for an aye vote.
Any discussion? Question is Senator Baumgartner.
I have a question. Thank you, Madam President. I was just wondering if this was for black-footed ferrets.
Senator Nicholson.
Thank you, Madam President. It is not specific for black ferrets. It's for ferrets and cats who are natural hunters, primarily for cats because they are natural hunters and sometimes will attack skunks, and the skunks are sometimes infested with rabies, and that spreads rabies, which is a deadly disease for humans.
Senator Harvey.
Thank you, Madam President. I meant to ask Senator Aguilar yesterday if I could offer an amendment to this bill, but I forgot to do it, so I just wanted to let everybody know about an amendment that the House offered to this bill in committee or on the floor. It said, a pet owner is exempt from the provisions of this subparagraph with the signature of a veterinarian, or if he or she takes an online course educating him or her about the potential dangers of vaccines.
Question before the body is the adoption of House Bill 1313. Are there any no votes? Senators Renfro, Baumgartner, Mr. Minority Leader, Senators Shuffle, Harvey, Lambert, Lundberg, Marble, Grantham, Rivera, King, Hill. With 23 ayes, 12 noes, 0 absent, and 0 excused, House Bill 1313 is adopted. Co-sponsors. General orders, second reading of bills. Mr. Majority Leader.
Thank you, Madam President. Before we do that, I move we proceed out of order for a moment of personal privilege for Senator Newell.
The motion is whether to grant Senator Newell a moment of personal privilege out of order. All in favor say aye. Aye. Opposed, no. Ayes have it. Senator Newell is granted a moment of personal privilege out of order. Senator Newell.
Thank you, Madam President. Members, this morning you received this little brochure on your desk, which Sir Kim said, you're a little late. It is October is Conflict Resolution Month, but actually we're very early. And the reason why we're early is that we are not in session during the month of October, and just wanted to point out that we are going to prepare you for that very shortly. In the interim, we will be giving you packets. We are the we're the first state, and there are only 2 in the country, that have October as Conflict Resolution Month. And that is a month where we are making sure that we're getting the word out about alternative dispute resolution across the state. And that is for fiscal responsibility to avoid litigation, to avoid mandatory arbitration, and make sure that we are allowing consensual I could also say nonpartisan conversations happening for reducing conflict. So I have a tribute this morning, Madam President, if I may, to the Mediation Association of Colorado. And the history of what they call the MAC is that since 1983, the MAC, formerly known as the Colorado Council of Mediators and Mediation Organizations, They have been the largest statewide private nonprofit organization dedicated to the promotion of the mediation profession and the use of mediation in all of its forms for possible alternative dispute resolution. Their vision is to achieve an environment in which the public values and seeks mediation as an effective choice to resolve disputes. And the MAC offers public and the courts access to experienced mediators bound by a code of professional standards and practices, and they are held accountable for their work. I am very proud at this time to, as I do every year, to talk about conflict resolution in an alternative way rather than looking at traditional forms, the fiscal realities that we're facing, and also the relationships that we're building with these kinds of practices are phenomenal. In your own communities, in your own town halls, you are welcome to have one of their speakers come and talk about alternative dispute resolution, which I do every year during the month of October. So this tribute says the Senate and House of Representatives convened in the second regular session of the 69th General Assembly hereby extends heartiest appreciation and proud to honor Mediation Association of Colorado. We recognize the opportunities of alternative dispute resolution practices and the dedication to these during the month of October. Conflict resolution, mediation, arbitration, facilitation, collaborative decision-making, and restorative justice are tools of fiscal responsibility and our growth toward peaceful communities. Professional associations dedicating their work to the promotion of creative dispute resolutions lead us all to dialogues that move conflicts to conversations of understanding and respect. On request of Senator Linda Newell and Representative Pete Lee, given this 22nd day of April 2014. So, members, I have members here from the conflict resolution community. If any of you would like, I have some of your constituents actually here with me today, and I would like to honor them in the work that they do every day in your own communities. Thank you.
Committee reports.
April 22nd, 2014, Committee on Appropriations. After consideration, the Mayor's Committee recommends the following House Bill 1072 be amended as follows and also amended for the Committee of the Whole. Favorable recommendation. April 22nd, 2014, Committee on Appropriations. After consideration, the Mayor's Committee recommends the following House Bill 1014 be amended as follows and also amended for the Committee of the Whole. Favorable recommendation. April 22nd, 2014, Committee on Appropriations. After consideration, the Mayor's Committee recommends the following House Bill 1170 be amended as follows and also amended for the Committee of the Whole. Favorable recommendation. April 22nd, 2014, Committee on Appropriations. After consideration, the Mayor's Committee recommends the following House Bill 1205 be referred to the Committee of the Whole. Favorable recommendation. April 22nd, 2014, Committee on Appropriations. After consideration, the Mayor's Committee recommends the following House Bill 1211 be referred to the Committee of the Whole. Favorable recommendation. April 22nd, 2014, Committee on Appropriations. After consideration, the Mayor's Committee recommends the following House Bill 1221 be referred to the Committee of the Whole. Favorable recommendation. April 22nd, 2014, Committee on Appropriations. After consideration, the Mayor's Committee recommends the following House Bill 1266 be referred to the Committee of the Whole. Favorable recommendation, and with the recommendation to be placed on the consent calendar. April 22nd, 2014, Committee on Appropriations. After consideration, the Mayor's Committee recommends the following Senate Bill 3 be amended as follows and as so amended before the Committee of the Whole. Favorable recommendation. April 22nd, 2014, Committee on Appropriations. After consideration, the Mayor's Committee recommends the following Senate Bill 176 be amended as follows and as so amended before the Committee of the Whole. Favorable recommendation. April 22nd, 2014, Committee on Appropriations. After consideration, the Mayor's Committee recommends the following Senate Bill 187 be amended as follows and as so amended before the Committee of the Whole. Favorable recommendation. April 22nd, 2014, Committee on Appropriations. After consideration, the Mayor's Committee recommends the following Senate Bill 164 be amended as follows and as so amended before the Committee of the Whole. Favorable recommendation. April 22nd, 2014, Committee on Appropriations. After consideration, the Mayor's Committee recommends the following Senate Bill 194 be amended as follows and as so amended before the Committee of the Whole. Favorable recommendation, with the recommendation to be placed on the consent calendar.
General Orders, second reading of bills, consent calendar. Mr. Majority Leader.
Thank you, Madam President. I request that House Bill 1204 be removed from today's second reading of bills consent calendar and placed at the end of today's second reading of bills calendar.
House Bill 1204 will be removed from second reading consent and placed at the end of the second reading calendar. General orders, second reading of bills. Senator Ulibarri. You've heard the motion. All in favor say aye. Aye. Opposed, no. Ayes have it. The Senate will resolve itself into a committee of the whole for purpose of considering general orders, second reading of bills calendar, and Senator Ulibarri will take the chair.
The committee will come to order and the court rule is relaxed. Majority Leader Heath.
Thank you, Mr. Chair. Colleagues, it's this time of year again. We're going to, from here on out, move all of the Senate bills up on the calendar so that we get them out of here and on their way to the House. So with that, I'm going to move that we proceed in this order with the general order second reading of bills. We'll go with Senate Bill 1, it will be in the order in which the Senate bills are listed. Senate Bill 186 first, Senate Bill 184, Senate Bill 185, Senate Bill 182, and then we will go back to House Bill 1011 and proceed in the order that the House bills are listed in the calendar.
You've heard the motion, and just to clarify, we'll be proceeding in this order: Senate Bill 186, Senate Bill 184, Senate Bill 185, Senate Bill 182, and then proceeding in order of the House bills listed in your calendar, beginning with House Bill 1011 and ending with House Bill 1204. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it. We'll proceed in that order. Mr. Majors, please read the title to Senate Bill 186.
Senate Bill 186 by Senator Schwartz and Kerr and Representative Tyler concerning the aggregation of efficiency projects in small communities in order to attract private sector investment through performance contracting.
Senator Schwartz. Senator Kerr.
Thank you, Mr. Chair. I move Senate Bill 186. There are no committee reports.
To the Local Government Committee report.
Thank you, Mr. Chair. I move the Local Government Committee report.
To the report. Senator Schwartz.
Thank you, Mr. Chair. So what the committee report does, it describes an amendment that actually one of our energy providers requested that we clarify the definition of efficiency projects and renewable projects, and we simply did that throughout the bill. And then we also identified that the appropriations were to be continuously appropriated. And so pretty basic definitional clarification for the bill. So I move I move again the committee report for local government.
Is there any further discussion on the committee report? Seeing none, the motion before the body is the adoption of the Local Government Committee report. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it. The committee report is adopted. To the bill.
Do you want to start?
You go ahead.
Okay.
Senator Kerr.
Thank you, Mr. Chair. Creating the Efficient Schools and Communities Performance Contracting Program is going to support our rural areas, small and low-income communities, municipalities, special districts, and schools. Efficiency upgrades are needed for buildings, water, and transportation infrastructure. The added benefit that we're looking at here is that these are jobs throughout Colorado, especially in our smaller and rural areas, that are desperately trying to get these upgrades done, but the projects are small enough scale that sometimes the financing of the projects can be an issue. This bill helps facilitate that, really helping to aggregate a number of these projects together into a single larger financing mechanism. And with that, we ask for your support.
Senator Schwartz.
Thank you, Mr. Chair. And just as a follow-up, this is a great, as we said, rural jobs bill. Again, it's voluntary. If folks would like to have projects in their communities included in performance contracting, that is what the opportunity is, and ask for an aye vote. And we have provided on everyone's desk a nice letter from the City of Montrose, the Director of Innovation Citizen Engagement, in support of the bill, as well as another rural efficiency group, CORE, and their interest in providing these opportunities for their small communities.
Is there any further discussion on the bill? Seeing none, the motion before the body is the adoption of Senate Bill 186. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it. Senate Bill 186 is adopted. Mr. Majors, please read the title to Senate Bill 184.
Senate Bill 184 by Senator Schwartz and Representative Quorum concerning oversight of the industrial hemp program.
Senator Schwartz.
Thank you, Mr. Chair. And I move the Local Government Committee report. I move Senate Bill 184, and I also move the Local Government Committee report.
To the Local Government Committee report.
The Local Government Committee report is speaks to an opportunity for our seed certification program, and also through the Department of Agriculture. It also speaks to the industrial applications for seed certification program. And what we did is we added a medical marijuana health research program eligibility, which we actually are going to be striking out of this committee report, but I would like to adopt the committee report first.
Is there any further discussion on the Local Government Committee report? Seeing none, the motion before the body is the adoption of the Local Government Committee report. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it. The committee report is adopted. There's an amendment on the desk. Mr. Majors, please read L007.
Amendment L007.
Senator Schwartz.
Thank you, Mr. Chair, and I move Amendment 7. Amendment 7 is a technical correction to the Local Government Committee report that, again, doesn't specify that industrial hemp can only be grown outdoors. It does strike that, so it can be grown outdoors or indoors. So again, I ask for an aye vote on Amendment 7.
Is there any further discussion on L007? Seeing none, the motion before the body is the adoption of L007. All those in favor say aye. Aye. Those opposed, no. The ayes have it. The amendment is adopted. There's another amendment on the desk. Mr. Majors, please read L008.
Amendment L008 to Senate Bill 184 by Senator
Stedman.
Thank you, Mr. Chair. I move Amendment L008. Colleagues, this is an amendment to the committee report to delete provisions that were added in committee regarding medical marijuana research. And I do this for a couple reasons. One is because there's another bill coming through sponsored by the JBC on that topic. And two, medical marijuana is something different from industrial hemp, and this, I think, doesn't even fit the bill title. So it's neater to do it under the medical marijuana research bill. So let's take it out of this one. I ask for an aye vote.
Senator Schwartz.
And thank you, Mr. Chair. And again, I appreciate Senator Stedman's addressing this in another bill and just creating the eligibility for hemp to be considered under the medical marijuana research program.
Is there any further discussion to L008? Seeing none, the motion before the body is the adoption of L008. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it. L008 is adopted. To the bill. Senator
Thank
Schwartz.
you, Mr. Chair. And again, this is an opportunity for a cleanup on our hemp production in the state of Colorado. It is an exceptional opportunity for Colorado to be in a position to have a hemp production, hemp crop, hemp industry, hemp products, but also what we're doing in this bill is clarifying those and those programs and the oversight of our Department of Agriculture. But secondly, we are creating this opportunity for hemp research, and that is medical research that can be done either under a provision for eligibility under other hemp, other marijuana funds that will be coming in, and then as we did take out that provision for eligibility that will be available under the medical marijuana research program. Lastly, it does provide an opportunity for seed research through the Department of Agriculture, and would ask for an aye vote.
Senator Bellmer.
Thank you, Mr. Chairman. Well, members, I rise in strong support of Senate Bill 184. Hemp is a magical crop that can address so many problems confronting our state and our country. I am for anything that is expanding the growing and use of hemp. Now, this is primarily focused on agricultural research, and I am not an expert on agriculture, but when it comes to hemp, I've learned that this is a crop that can do a lot of things that fit very well with dryland farming in Colorado. The research that's going to be done, and it's gentleman from Ray's looking at me like, what do I know about dryland farming in Colorado? And that's true. You're correct about that. I was off camera. You didn't see it. But this research is going to be focusing on hemp cultivars. It's going to be focusing on coming up with hybrids that are not only figuring out which hybrids grow the best in Colorado, but which hybrids will do the best to develop end uses. So certain types of hemp hybrids will work well for fabrics. Other types of hemp hybrids will work well for fuel use. And I think that we should do everything we can to support hemp here at the state level. We are fortunate that in the Federal Farm Act that they just passed, actually, that's what I said was correct. They actually passed a bill in Congress. They actually passed a much stripped down federal farm bill. But in any event, part of it was allowing states that have legalization of hemp, which we are one, to do research on hemp. And there's several ways they can do it, but we've got an extraordinary program in Colorado that's going to take advantage of the industry use, the university programs, and so I am a strong supporter of Senate Bill 184, and I want to thank the sponsor for bringing the bill.
Is there any further discussion on Senate Bill 184? Seeing none, the motion before the body is the adoption of Senate Bill 184. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it, and Senate Bill 184 is adopted. Mr. Majors, please read the title to Senate Bill 185.
Senate Bill 185 by Senators Johnston and Zenzinger and Representative Pedersen concerning pay for success contracts for successful early childhood education services programs.
Senator Johnston.
Thank you, Mr. Chair. I move Senate Bill 185, and I move the Education Committee report.
To the Education Committee report.
Thank you, Mr. Chair. We added one technical amendment of the Education Committee, and the second amendment was an amendment clarifying that there was a broader definition of early education services that includes 0 to 3 services as well as 3 to 5.
Is there any further discussion to the Education Committee report? Seeing none, the motion before the body is the adoption of the Education Committee report. All those in favor say aye. Those opposed, no. The aye has it. The report is adopted. To the bill, Senator Johnston.
Thank you, Mr. Chair. I move Senate Bill 185. Senate Bill 185 is an innovative approach to try to provide a voluntary, I moved Senate 185, I think, right? I moved Senate 185. This is a voluntary pilot program to explore creative ways to help fund early education services from ages 0 to 5. It allows local organizations, nonprofits, human services departments, early childhood providers to voluntarily enter into contracts that would help them identify sources for funding and would help them pay the costs of those sources of funding if they meet predetermined savings outcomes that they jointly agree. And so this simply allows some local innovation and a creative way to fund early childhood services for districts that want to try it. We'd ask for an aye vote.
Is there any further discussion to Senate Bill 185? Seeing none, the motion before the body is the adoption of Senate Bill 185. All those in favor say aye. Aye. Those opposed, no. The ayes have it. Senate Bill 185 is adopted. Mr. Majors, please read the title to Senate Bill 182.
Senate Bill 182 by Senator Hodge and Representative Peniston concerning procedures governing discussions by boards of education or school districts while meeting in executive session.
Senator Hodge.
Thank you, Mr. Chair. I move Senate Bill 182. There is no committee report. What Senate Bill 182 is amends the school board sections of our state statute that adds that they keep track of the time for each topic they discuss in their executive session. And I ask for an aye vote.
There is an amendment on the desk. Mr. Majors, please read L001.
Amendment L001 to Senate Bill 182 by Senator Talk Drop. Amend print and bill, page 3, line 23, strike 24 months and substitute 90 days.
Senator Talk Drop.
Thank you. And I would move L001.
Please proceed.
And what this does, it just changes the, just states that instead of saving the tapes for 24 months, that they would save them for 90 days. And this lines it up with everything else that the school boards save, and I just asked for an aye vote on L001.
Is there any further discussion on L001? Senator Hodge.
Thank you. Friendly amendment, I'm fine with it. Vote yes.
Any further discussion? Seeing none, the motion before the body is the adoption of L001. All those in favor say aye. Aye. Those opposed, no. The ayes have it. L001 is adopted. To the bill. Senator Renfro.
Thank you, Mr. Chair. Members, I'd ask for a no vote on this bill. This is unnecessary. School districts right now, when they post their agenda, they place on the agenda the reasons that they're going to go into executive session. And this is micromanaging what a board does. I just ask for a no vote. To take the time to have to post on your website for 90 days, for 24 months, the amount of time you spend in executive session on each topic. Do we do this for any other boards or any other entity in government that goes into executive session? You know, why are we doing this? And I think the reasons are that we heard in committee, because we did hear this bill in Education Committee, were unjust. I mean, well, we don't know what they're doing. They're spending too much time. We want to know the topics that they're on. Members, if you don't trust your school board members, then elect different school board members. If you think they're abusing what they're doing, that's what the process is to fix this. It's not to try and differentiate every minute they spend in executive session on what topic it is. In some districts, as small as they are, I think this could even cause conflict within executive session, because you would actually know, basically, if they were in on a personnel issue, you would know who or what or why they were there on some instances, which I think defeats the purpose of executive session for personnel reasons. So I'd ask for a no vote on this bill.
Senator Hodge.
Thank you, Mr. Chair. You already have to say why you're in executive session. So if you're there for personnel, it is a very minute manner to say you're on personnel from 10:01 to 10:07 and to put that as part of your minutes. You already have to mention it in your minutes. It's one addition. I ask for an aye vote.
Senator Kerr.
Thank you, Mr. Chair. I stand in support of Senate Bill 182. We have seen in recent years various government agencies abuse their power and abuse their power of going into executive session. I think that this is a reasonable compromise to make sure that the public is informed, that there is transparency around what is happening behind closed doors. Our public demands this. Our public, the people who elect us, don't elect us to just go behind a closed door and make decisions in secret. They elect us to have open discussions. They elect all of their elected officials to be open and honest and have open and honest conversations. I think that this is a reasonable measure to make sure that people who elect their officials to go and make important decisions, that they have confidence that their elected officials are actually having conversations for the public good. I ask for an aye vote on Senate Bill 182.
Senator Renfro.
Thank you, Mr. Chair. Members, this is not a reasonable measure. This is an extreme measure of micromanagement and not trusting the school boards. How can we come to this well and say, oh, they're making decisions in secret, they're not telling us how they're voting, they're not explaining their vote or how they got to that, they're just getting up and voting when they get there? We never see that in the Senate, do we? Wow, we never see that here. Do we always explain our vote? Are we not representing our people if we don't come down here every single time and explain our vote? Stop being hypocrites. Vote no on this bill.
Senator Crowder.
Thank you, Mr. Chair. I believe that this is already set up the way we do school boards as well as any other boards. I'm not sure that I agree with bringing this forward just for school boards. If you look at the Pueblo paper just the last few days, you had a city councilman bring forward something that he did not agree with in executive session. And the reality is the attorneys or the lawyers are the ones that dictate as to what subject matter can be talked to in executive session. So this is out of line specifically for a school board, because I do believe the laws are already in place for all boards. Thank you. Vote no.
Is there any further discussion? Senator Hodge.
Thank you, Mr. Chair. This amends only the school board portion of our laws. It does not do all those other boards, and the only thing it does is add the keeping of the time.
Is there any further discussion on Senate Bill 182? Seeing none, the motion before the body is the adoption of Senate Bill 182. A division has been requested. All of those in the chamber who are not entitled to vote, please be seated. A division has been requested. Again, I'll state, all those in chamber not entitled to vote, please be seated. The motion before the body is the adoption of Senate Bill 182. All those in favor, please stand. Please be seated. All those opposed, please stand. Please be seated. The motion is adopted. Senate Bill 184 is adopted. Sorry, yeah, 182. Senate Bill 182 is adopted. Mr. Majors, please read the title to House Bill 1011.
House Bill 1011 by Representatives Young and Jerome and Senator Heath concerning the funding of advanced industry economic development programs.
Mr. Majority Leader.
Thank you, Mr. Chair. I move House Bill 1011 and the Finance Committee report.
To the Finance Committee report.
Thank you, Mr. Chair. The Finance Committee report merely reduced the amount of money appropriated to this bill from $10 million to $5 million.
Is there any further discussion on the Finance Committee report? Seeing none, the motion before the body is the adoption of the Finance Committee report. All those in favor say aye. Those opposed, no. The ayes have it. The Finance Committee report is adopted. To the bill, Majority Leader Heath.
Thank you. This provides funding for 2 additional years. This is a bill that we passed originally back in 2009, modified it last year, And this year basically provides additional funding. This has been infinitely successful, and I would ask for an aye vote.
Senator Lambert.
Thank you, Mr. Chair. I hadn't asked to be recognized, I don't think, but I do have a question. How come this bill hasn't gone to appropriations if it's changed the appropriations clause from, I think you said 10 million to 5 million?
Senator Heath, would you like to respond?
I don't know the answer to that.
Senator Lambert.
Well, I ask if there's some reason why we can't make a motion to move this to appropriations to go through the rules as have been given to the Appropriations Committee.
We'll take a senatorial 5. The committee will come back to order. Majority Leader Heath.
Thank you, Mr. Chair. It appears that the good senator, I'll say his name, Senator Lambert, in this case is correct. This bill should have been routed through appropriations, and I would move that we refer it back to appropriations.
That's an appropriate motion. You've heard the motion to refer back to appropriations. All those in favor say aye. Aye. Those opposed, no. The bill will be referred back to appropriations. Mr. Majors, please read the title to House Bill 1260.
House Bill 1260 by Representative Foote and Senator Johnston. Concerning the creation of 3 mandatory minimum presumptive ranges for defendants convicted of a felony sex offense involving intrusion against a child who is under 12 years of age when the adult defendant is at least 10 years older, that has one of the ranges starting at 10 years as the minimum in the range, and in connection therewith creating an indeterminate lifetime sentence with a mandatory minimum presumptive range of 10 to 16 years for a Class 4 felony, a mandatory minimum presumptive range of 18 to 32 years for a Class 3 felony, and a mandatory minimum presumptive range of 24 to 48 years for a Class 2 felony.
Senator Johnston.
Thank you, Mr. Chair. I move House Bill 1260.
And you also have an Appropriations Committee report?
Oh, sorry, and the Appropriations Committee report.
To the Appropriations Committee report.
Thank you, Mr. Chair. This just renumbered sections and struck section 18, struck 5 lines on the appropriations clause.
Is there any further discussion on the Appropriations Committee report? Seeing none, the motion before the body is the adoption of the Appropriations Committee report. All those in favor say aye. Those opposed, no. The aye has it. The report is adopted. To the bill, Senator Johnston.
Thank you, Mr. Chair. Members, this today is, I bring you Colorado's Jessica's Law, which is a topic you've heard debated probably a great deal. But for all those who have kids or for those who have grandkids or nieces or nephews, there's probably no greater nightmare than the one that we heard testified to in committee, which is folks who have young children who are abducted and sexually assaulted and sometimes killed. And there's probably no greater nightmare for a parent than that happening to your child and then knowing that the perpetrator gets probation or gets released on a minimal sentence and goes back out into a neighborhood or a community like yours or like mine where there are kids running to school, playing out in the playgrounds, and you put those kids and those families at risk again. And so this bill tries to solve that by putting in place some mandatory minimum sentences for the most egregious of sexual offenses. The requirement is that you have someone who is over age 21 and that the child is at least 10 years younger, so the child must be 12 years or younger. And these involve the most heinous of crimes, the actual sexual penetration and molestation of these kids. So these are not the close calls. This is not a 19-year-old and a 17-year-old. This is not a groping of someone on the bus. This is the most deliberate and egregious types of sexual crimes on children, for which I think we have an obligation to protect our kids and our communities. So I would humbly ask for an aye vote on House Bill 1260.
Is there, Senator Herpin?
Thank you, Mr. Chairman. It's very appropriate that we're discussing House Bill 1260 during National Child Abuse Prevention Month. On February 24, 2005, 9-year-old Jessica Lunford went missing from her bedroom. When a child is reported missing, the police typically check all known sex offenders in the area, and detectives from Citrus County Sheriff's Office did just that in the days following Jessica Lunford's disappearance. In the course of their investigation, detectives discovered that one known sex offender, John Cootie, age 46, was not living at the address where he was registered. A convicted sex offender is required by law to notify local authorities if he intends to change his place of residence. On March 18, 2005, John Cootie was arrested and confessed to kidnapping, raping, and burying Jessica alive. Her body was discovered the next day where Cootie said it would be. Cootie had a long list of convictions on his rap sheets. He had been arrested on many occasions for drug violations, was a habitual user of crack cocaine. According to the Citrus County Sheriff's Office, past charges against Cootie included burglary, carrying a concealed weapon, disorderly intoxication, driving under the influence, indecent exposure, disorderly conduct, fraud, insufficient funds, and larceny. His driver's license had been suspended for 99 years. In 1991, he had been arrested and charged with fondling a child under the age of 16. In response to Jessica's murder by a previously convicted sex offender, on September 1, 2005, the state of Florida enacted a new law of lewd molestation, and upon conviction, the molester would be sentenced to a minimum of 25 years in prison and enhanced electronic monitoring if released on parole. This law is called Jessica Lunford Act, or Jessica's Law, in memory of Jessica Lunford. Had this law been in effect when Cootie was convicted in 1991 for sexually molesting a child, Jessica Lunsford would be alive today. Since 2005, 45 states and the District of Columbia have enacted some form of Jessica's Law. While House Bill 1260 is not the full implementation of Jessica's Law in Colorado, it is an important step in the right direction and does increase the minimum mandated sentence for a person convicted of a Class 2, 3, or 4 felony of raping a child under 12 as long as there is penetration or intrusion. Jessica's father, Mark Lunsford, who testified in person last year on a bill to implement Jessica's Law in Colorado, has agreed that this is a good bill. As the grandfather of 4 young granddaughters and 3 grandsons, I respectfully request your support for this important protection for our children. House Bill 1260, coupled with existing Colorado law requiring treatment and monitoring of those convicted of sexual crimes against children,
provides increased protection for those who would harm our young children. Thank you.
Is there any further discussion on House Bill 1260? Seeing none, the motion before the body is the adoption of House Bill 1260. All those in favor say aye. Aye. Those opposed, no. The ayes have it. House Bill 1260 is adopted. Mr. Majors, please read the title to House Bill 1061.
House Bill 1061 by Representative Salazar and Senator Guzman concerning sentences imposing monetary payments and criminal actions in a connection therewith eliminating prison sentences for persons who are unable to pay criminal monetary penalties.
Senator Guzman.
Thank you, Mr. Chair. I move House Bill 1061 on second reading.
Please proceed.
Thank you. Thank you, Mr. Chair. Members, this bill is about a very major, important arena. Courts throughout Colorado are sending impoverished people to jail, not because they've committed crimes, but because they cannot pay fines for violations as small as traffic offenses or dog leash and pet licensing laws. It's a practice that many say violates the United States and the Colorado Constitution. In fact, Section 12, Article 2 of the Colorado Constitution forbids persons to be jailed simply because they owe a fee or a fine. But in 9 of the largest 16 cities in Colorado, the ACLU found that judges routinely issue pay or serve warrants against those too poor to pay court fines. In such cases, individuals are given a stark option: pay up in cash or pay off fines by serving time in jail. In one of the communities, unpaid court fines as little as $90 can result in a 10-day jail sentence. In another situation, a presiding judge issued a standing order in 2001 that remains in effect today that requires a defendant to be jailed for 10 days for failure to pay a court-ordered fine, no matter how small the amount owed. So, members, this bill would change this situation. This does not mean that those folks who owe can get off free. It is left up to a judge to decide the indigence of an individual. If they are indigent, the judge can set up payment plans or other kinds of plans. If a person, though, falsifies their information and basically says to the court that they cannot pay, but it's found that they could in fact pay, then there are serious consequences for those people, and they would probably, there would be the right to offer jail time to them because they have been in contempt of the court. So this bill was passed in the House unanimously. It was passed in the Judiciary Committee unanimously. We heard from an individual who ran afoul in 2012, shortly after he lost his job, his oil rig job, and his company paid housing after a chemical burn to his left eye. He was homeless and hoping to scrape together whatever he could for a motel room when a police officer stopped him. He had made a wrong turn and was driving a defective vehicle, a non-jailable offense, according to the Colorado Revised Statutes. He was ordered by a judge to pay $306.25 in fines, but he could make an initial payment of only $61.25, records show. 8 days later, the judge issued an order for his arrest, demanding final payment or 10 days in jail. This man went to jail because he could not pay. There are many, many situations like this, and this bill, we are asking support of this bill so that Colorado can fix this terrible injustice that is coming to many people. So with that, Mr. Chair, I ask again for the support of this House Bill 1061.
Thank you. Senator Marble.
Thank you, Mr. Chair. I want to thank the bill sponsor for bringing this forward. I think it is a great idea. I just had a question regarding a work-ender program. If they are not imprisoned for owing a fine or a fee to the court, which I agree with, then are they still able to go through a work-ender program and maybe do some of the work to work off that debt that the court has imposed?
Senator Guzman.
Thank you, Mr. Chair. And yes, Mr. Chair, the answer to that question is that is certainly one of the options that the courts could address. There are many options. One could be a work in the community, something like that as well. Yeah. In other words, to continue, a judge could determine that they would do away with the fine, but most instances the judges are going to find another way in which this person can take care of their fines, and that could be, work in the community. It could be a payment plan. It could be many of those things.
Senator Crowder.
What was that bill number?
House Bill 1061.
Yeah, I'm going to stand in support of this bill. I do believe that there are alternative ways to, garner funding from some of the OZA money. And to say that jail is the only way that it can be done, I do not believe that that's prudent in this society. So I'm going to be supportive of this bill because when someone goes to jail for owing money, it causes an additional burden on society. And I think the way to do this is follow the Constitution, which we have, and I do believe that I will be supportive of this. Vote yes on it. Thank you.
Senator Johnston.
Thank you, Mr. Chair. And I rise in support of this bill, too. It's a really important bill. And for folks who weren't in committee to hear testimony, it was really quite astounding. I mean, not just on the human rights violations of someone that doesn't have the ability to pay, but on the sheer economic insanity of this. We had a young man testify who owed a $70 fine and got sentenced to 10 days in prison for that fine. Now, you can do the math pretty quickly on what the daily rate charge is for prison in this state or even for a county jail. We spent far more money to incarcerate him for 10 days, not counting the 10 days of work he missed, the 10 days of food he couldn't support for his family, the 10 days of other value he couldn't add to society. But literally, we paid more in state dollars to put him in jail for 10 days than he owed us from the lost fine. So I think this is not just bad human rights practice. I think it's bad fiscal practice. So I thank Senator Guzman for bringing this and ask for an aye vote.
Senator Hill.
Thank you, Mr. Chair. Colleagues, I ask for your support on this bill as well, and it goes beyond just the economic issues. What we have here is a basic, the integrity of our judicial system is really what's at stake, and this goes back to even the founding of our country, recognizing that jail was not the answer to so many of the issues, so many of the problems that societies have perennially faced. And right now we find ourselves in a time when 1 out of 100 U.S. citizens is in jail. 1 out of 100 U.S. citizens is in jail, and colleagues, this is inappropriate for us as a society, and especially when we consider the fact that, right, we've argued against these excessive court fines, we've argued against using fees, we've argued against using the judicial system to nickel and dime people to death to manage a bureaucratic and a regulatory state. Why would we now support, under the guise of being tough on crime, why would we now support arguably an unconstitutional, against the founding of this country in an unjust system, to enforce the bureaucratic state that we spend so much of our time arguing against. I encourage your support on this and recognizing that this is a natural area where we can come together and see that jail time is not the answer to bureaucratic fines.
Senator Lambert.
Thank you, Mr. Chair. I wanted to mention one example of how this has played out in another state. I happen to know a judge out in California who really set some models in how veterans courts worked in that state. I sent some of that information to the chief administrator of the Colorado Supreme Court a couple of years ago, and I think we've started to expand that into our own Colorado veterans courts. Those have been very successful, and they're expanding. I think they started first in 4th Judicial District in El Paso County, but now are expanding throughout the state. But one of the things I don't think we fully exploited is a practice that they have in California where judges can actually go out of the courtroom into the community and especially work with veterans in what is called a veterans stand down. That's for veterans who have either behavioral health problems or face poverty, homelessness, things like that. And veterans organizations around the state are able to have, in like an auditorium or an outdoor setting or something, get veterans together. They'll announce this, provide special services for those veterans from a variety of programs, get them eligible and so forth to receive services from the state and whatever. But one of the unique things that they did in California was actually hold court during a veterans stand-down situation where the bailiffs of the court would actually start the court proceedings on a Friday, get all the information from the veterans about petty offenses that might have been in the records against them that quite often drove them underground. One of the common petty offenses was riding on the light rail system for hours and hours and hours and getting a ticket for riding light rail and not getting off because they were trying to stay out of the rain or trying to get warm and things like that. But because they were repeat offenses, sometimes they had dozens of tickets for riding on the light rail. And I think an enlightened way that the judges handled that was to say, okay, we're going to accumulate all these things that are making you fearful of actually solving your problems or coming to the court, and we're going to expunge some of those repeat offenses if you promise to take this ticket down here and pay the, whatever it was, the $10 fine, or actually buy a ticket and start over again, with some counseling, with some other documentation of what they'd been doing to encourage them to get off that repeat offense track. I haven't seen that done to the same extent here in Colorado, but I wanted to mention it because I think that's something that we should be doing around the state when we have repeat petty offenses that hang over the heads of defendants in the court system, especially indigent or homeless people, that we could actually engage in a positive manner to get those fines or possible jail time off their record and actually help them get back onto track, especially for homeless veterans and others who are really just trying to stay out of the rain or the snow. And you know, I think this is gives some flexibility in doing that. So I'd ask for an aye on the bill as well.
Is there any further discussion on House Bill 1061? Seeing none, the motion before the body is the adoption of House Bill 1061. All those in favor say aye. Aye. Those opposed, no. The ayes have it. House Bill 1061 is adopted. Mr. Majors, please read the title to House Bill 1280.
House Bill 1280 by Representative Dover Schwartz concerning limits on liability for agritourism.
Senator Schwartz.
Thank you, Mr. Chair. Is that loud enough? Thank you. I was asked to speak a little bit louder at the mic, so move that mic down. Thank you. And Mr. Chair, I move House Bill 1280, and there is a agritourism, there's Agriculture, Natural Resources, and Energy Committee report.
To the committee report.
So the committee report is basically a strike below that does help us clarify all of the information in the bill relative to agritourism and liability exemption. This was an amendment that we worked out with other industries that are associated with liability exemption, for example, the equine folks, as well as the Dude Ranch folks. And we wanted to make sure that we didn't diminish any of the exemptions that are currently in statute. And so the Agriculture, Natural Resources, and Energy Committee report is the bill. So I'm, again, move for adoption of that committee report.
Is there any further discussion on the Agricultural Natural Resources Committee report? Seeing none, the motion before the body is the adoption of the Agricultural Committee report. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it. The committee report is adopted. To the bill, Senator Schwartz.
And thank you, Mr. Chair, and again, move House Bill 1280. What we have here is an opportunity for encouraging and building a robust agritourism industry in the state of Colorado. We are finding more and more folks that are interested in having people come on their farms and their ranches for experiences. And when we were putting together a basically feedback from over 400 individuals that were contacted statewide on these regional road shows through the tourism office, we found that there were a couple issues that rose to a level of concern for them, one being the liability and exposure to liability, and they wanted to make sure that they were adequately protected when they communicated the inherent risks to the folks that were coming on to their property, and that they, in fact, would enjoy similar exemption that we see in, as I said, in other experiences. So with that, I will ask for an aye vote on, again, an opportunity to boost agritourism in the state of Colorado as part of our tourism experiences.
Senator Brophy.
Thank you, Mr. Chairman. And members, I have a question to ask the sponsor just for legislative intent, but first I want to give you a little history of how we got to here. Back in 2003, the General Assembly established some liability protections for farms and ranches who wanted to allow people to come onto their property for pay to participate in ag activities. We called it at the time agricultural recreation. This bill is renaming it agritourism. And the legislature declared that participation in these agricultural activities was inherently dangerous and granted about the greatest amount of liability protection to the owners of farms and ranches that you can grant, basically saying that unless you are grossly negligent, you're not going to be held liable if somebody gets hurt by an animal or falls into a fence and gets themselves cut up or something like that on your property. And that was a good step for the people of the state of Colorado, especially in the rural areas where they wanted to do these types of activities to bring in additional revenues on their farms. This bill makes an improvement to that existing statute, and it does also rename ag recreation as agritourism, which I think is a good way to name it. And she's going to clarify something on that. But before we do that, I want to ask the sponsor, this bill specifically allows for a written waiver and or the posting of signs on the property to help establish the liability protections that come with agritourism. However, I want to make clear that you do not have to have a written waiver or post a sign to enjoy the liability protections if you decide to do agritourism on your place. So that's my question to the sponsor. Is it the intent of the sponsor that you still maintain liability protections even if you do not have the written waiver or post the sign?
Senator Schwartz.
And thank you, Mr. Chair, and for the good senator from Ray, I appreciate your interest in the bill. Actually, what we did in working with some of the other members of the agriculture community, we simply left agricultural recreation in place, and we added the words "or agricultural tourism." So we just added that to the statute that you are extremely familiar with. We just left everything in place, simply added agritourism to that, and certainly there is in there, we left the word, the operator of a facility may provide notice of the inherent risks of agricultural recreation or agritourism activities, either by a statement signed by the participant or by a sign. So that word may was, again, lifted out of the old statute, and we really kept in place agricultural recreation because it has a slightly different definition than agritourism, yet we wanted to have the opportunity to define agritourism in statute because of its opportunity to provide experiences of that nature, which could in fact differ. So I felt this was an excellent compromise. Certainly our legal friends also took a look at it, and it does not exempt a worker. It does not exempt someone in the employ of a facility for agricultural recreation or agritourism, and according to the statute, it really does provide protections for the landowner for that recreational or agritourism activity.
Is there any further discussion on House Bill 1280? Senator Brophy.
Thank you, and thank you to the sponsor for the clarification that the may means that you can do these things, but you're not required to do these things. And with that, I will ask for an aye vote on this. I think it's an important improvement to the liability protections that we have on farms and ranches, and appreciate the sponsor bringing this bill along with Representative Dorr in the House.
Is there any further discussion on House Bill 1280? Seeing none, the motion before the body is the adoption of House Bill 1280. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it. House Bill 1280 is adopted. Mr. Majors, please read the title to House Bill 1126.
House Bill 1126 by Representatives Williams and Buckner and Senator Nicholson concerning the requirement to include notification to a patient regarding the patient's breast tissue classification with the required mammography report.
Senator Nicholson.
Thank you, Mr. Chair. I move House Bill 1126. There are no committee reports.
Senator Nicholson, I have Health and Human Services Committee report listed in the calendar.
Oh, I apologize. Let me check. Thank you. I apologize. In Health and Human Services Committee, we changed the language from doctor to healthcare provider for who the information would go to regarding a finding of dense breast tissue. And we also changed the date to implement to January 1st, 2015 from July 1st, 2014.
Senator Nicholson, will you please move the Health and Human Services Committee report?
I move the Health and Human Services Committee report.
Is there any discussion on the Health and Human Services Committee report? Seeing none, the motion before the body is the adoption of the Health and Human Services Committee report. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it. The committee report is adopted. To the bill, Senator Nicholson.
Thank you, Mr. Chair. Starting on January 1st of 2015, the mammography report that each patient identified as having dense breast tissue receives would also include a specific notice regarding dense breast tissue. The notice would say your mammogram shows that your breast tissue is dense. Dense breast tissue is common and not abnormal. However, dense breast tissue can make it harder to evaluate the results of your mammogram and may also be associated with an increased risk of breast cancer. This information about the results of your mammogram is given to you to raise your awareness and inform your conversations with your healthcare provider. It is simply a matter of notice. The Susan G. Komen Foundation found that women with high breast density as seen on a mammogram are 4 to 5 times more likely to get breast cancer than women with low breast density. We don't know the entire reason for that because there's not been as much research as we would like, but we do know that certain populations are at much higher risk, and for that reason it seems prudent for us to encourage these women to have regularly scheduled mammograms and also breast exams.
Senator Aguilar.
Thank you, Mr. Chair. Members, I wanted to explain why I was a no vote on this in committee. I think ultimately our goal is to improve breast cancer survival, and I don't think that this bill will help us to do that. Amongst other things, the notifying women of dense breast sets up additional areas of anxiety where there's no proven intervention. There actually is no standard for diagnosing dense breast, so if 4 different radiologists see your breasts, you might be told by some you're dense and by others you're not. That has nothing to do with your mental capacity. And there's also no standard for follow-up for dense breast that lead to improved outcomes. So it's not clear whether, even if you know you have dense breast, whether you should get an MRI or an ultrasound, or that we can do anything to change your outcome. And I think this will lead to a lot of women being anxious about something that the science just is not there for yet. In addition, anytime you tell doctors that they need to be telling patients something, they tend to over-tell patients, and I think we'll see more patients being told that they have dense breasts for providers wanting to avoid liability. And, finally, I think we'll see an increased use of MRI and ultrasound, which again has no proven benefit on outcome. And finally, actually, really is that I don't think it's our role to set the standard of medical care in statute, and that's what this bill would do. And for that reason, I was a no vote in committee, and I will be a no vote today.
Is there any further discussion on House Bill 1126? Senator Hill.
Thank you, Mr. Chair, colleagues. I agree. I'm concerned the healthcare world is a dynamic, it's a fast-moving world. And for us, I'm not sure if any of y'all have recognized this, but it turns out we're not dynamic and fast-moving in here. We're not supposed to be. That's not the intention. We're supposed to be a deliberative body and take our time. And by putting ourselves in a very complicated issue right now, I think we're actually gumming up the wheels. Not only are we making our mothers, our wives, our family members safer when it comes to a very important issue with breast cancer here, but we could actually be further endangering them by going down this path. Because now, if we take it out of the hands of doctors who are well-trained, who are working with their patients, and we put this one-size-fits-all policy in place, we actually undermine their ability to get the dynamic, customized, tailored approach to health care that they actually need. So I encourage us to relook at ways to deal with breast cancer, but not to support this one.
Is there any further discussion on House Bill 1126? Seeing none, the motion before the body is the adoption of House Bill 1126. All those, a division has been requested. All of those in the chamber not entitled to vote, please be seated. A division has been requested. The motion before the body is the adoption of House Bill 1126. All those in favor, please stand. Please be seated. All those opposed? Oh, there is another one in favor. Yeah. All those opposed, please stand. The bill is lost. Mr. Majors, please read the title to House Bill 1354.
House Bill 1354 by Representatives Buckner and Gardner, Senators Aguilar and Crowder, concerning the ability of a county clerk and recorder to seek judicial review of final action by the Secretary of State relating to elections.
Senator Aguilar.
Thank you, Mr. Chair. We move House Bill 1354 and ask for your support.
Is there any further discussion on House Bill 1354? Senator Crowder.
Thank you, Mr. Chair. The only thing with 1354, Secretary of State thought they had this in preview. So all this does is clarify what they already have. It's a good bill, and it will advance. Thank you. Ask for a yes vote.
Is there any further discussion on House Bill 1354? Seeing none, the motion before the body is the adoption of House Bill 1354. All those in favor say aye. Those opposed, no. The ayes have it. 1354 is adopted. Mr. Majors, please read the title to House Bill 1288.
House Bill 1288 by Representative Pabon and Senator Aguilar concerning personal belief exemptions to immunization requirements for children prior to attending school.
Senator Aguilar.
Thank you, Mr. Chair. I move House Bill 1288 and the State Veteran and Military Affairs Committee report.
The committee report.
In the committee, we removed the requirement for parents to undergo mandatory education before claiming a personal belief exemption.
Is there any further discussion to the committee report? Seeing none, Senator Harvey.
Thank you, Mr. Chair. Thank you, Mr. Chairman. Gosh, I still don't have a voice. I appreciate the fact that we took this amendment out of the bill, this portion of the bill out by amendment in committee. My concern is that the House did not, and the House will put this back in, and we will be going to conference committee, and this amendment will still be in there. Do we have any assurance by the sponsor of the bill that she will fight to make sure that this amendment stays on in the conference committee if we're going to vote this bill out of the House, out of the Senate and send it to the House?
As a point of order, we're discussing the committee report, not whether or not we're going to conference. Yeah. That's what I'm asking. Senator Aguilar.
Thank you, Senator Harvey. And yes, I recognize that there's not the support in the Senate to do this, and I would not agree to put it back on in conference committee.
Is there any further discussion on the committee report? Seeing none, the motion before the body is the adoption of the State Veteran and Military Affairs Committee report. All those in favor say aye. Aye. Those opposed, no. The ayes have it. The committee report is adopted. To the bill, Senator Aguilar.
Thank you, Mr. Chair. The bill is amended simply directs that our CDPHE do create evidence-based education that's available to parents who would like to see it. There's no requirement. And it would probably be good for parents who are taking and refusing vaccines to take a look at that. And in addition, and part of why I still support this strongly, is that it is asking that schools make available upon request information regarding the immunization and exemption rates in their schools. And members, as you're aware, we have a lot more children surviving conditions that they did not survive before that can put them at risk for serious diseases if they have exposures. And so this is really as a service to parents of children with medically fragile children to be sure they don't receive any hassle in trying to obtain information about vaccination rates at their schools. And then it also asks CDPHE to help provide technical assistance to the schools regarding how to analyze and interpret and provide immunization data, and I'd ask for your support.
Senator Nicholson.
Thank you, Mr. Chair. I rise in support of this bill as it's amended. Because of my background in public health, I probably have provided more childhood immunizations than anyone else in the legislature. So I do feel like this is a topic that is very important and certainly important to me. I feel as amended, this bill will have an impact on the rates and be able to protect children from vaccine-preventable childhood diseases, and that is our primary goal with any of the legislation that we're supporting regarding immunizations. I feel that prior to the amendment of the bill, the measures that were proposed would not have had the result that we were hoping for, partly because I think many of the parents who did not present an immunization record but signed a personal exemption form actually had just simply lost the record. So this would have not had a significant impact on vaccine preventable childhood diseases declining in the state as we would like.
Senator Lundberg.
Thank you, Mr. Chair. Members have been following House Bill 1288 carefully as it's worked through the system. Indeed, as there was preparation for it all of, or much of last year, I know there was quite a bit of effort by proponents of this measure to lay the groundwork to make this bill reality and law as it was originally written. I certainly applaud the amendment that occurred in State Affairs. I think it did remove the major concern that parents have, and I put that in the present tense because they continue to have, because the way I saw this bill before it was amended is it was the re-education bill. You know, that's what it was there for, was to force parents into a training program. And here's the concern, because I have no problem with parents having all the facts before them. Indeed, they need all the facts. How many are parents here? I am a parent. Most of you are parents. And I remember when my now 30-year-old son was first being vaccinated, and my wife being a registered nurse who was working full-time in a hospital here in Denver, and consequently he found himself in the daycare center there at the hospital, which is about the worst place to put a little kid. You know, it's not just daycare, it's daycare among people who work at hospitals with every disease known to mankind. And so we were quite concerned with the whole thing until he had that first reaction to that DPT shot, a significant reaction. And of course, DPT contains the pertussis component, which there are boosters for. So it's not just a one-time thing, it's a several stage situation. And in our estimation, his reaction was too strong. It wasn't just a little swelling and a little grumpiness after the fact. No, it was a high-pitched scream that was something completely out of our experience with our son in any other painful situation. Here's the dilemma. Information is not given to parents today. And the reason I am so grateful that we have amended this bill, and I too am very concerned that the House not be allowed to change it back to the original form, is the information given is incomplete. It's not full disclosure. No, it's one side of the discussion. And I'll submit to you an example. We were all given this book, Giving Your Child a Bright Beginning Parent Handbook, at the beginning of the session. And this was from the Bright Beginnings group. And it has a section on immunizations. And I went and I read that, and it says, why does my child need vaccinations, side effects of vaccinations, where can my child get vaccinations, and all the other issues it seems to be a nice, friendly thing. If you read this, you don't get the full picture. What you get is the, dare I say it, propaganda that says your child must be vaccinated and there should be no question about it. That's not good science. That's not good information. And that's why I was opposed to the bill in its original form, because I'm confident, having watched this process for now some 30 years, because my experience with my own firstborn gave me a greater sensitivity to this issue, and I've talked to many, many parents, and including those who have had severe reactions. Good friends of my wife and myself have a daughter up in New York State, and she's been deaf ever since she had her vaccinations. Some other friends that we have, their daughter actually had a severe brain reaction and is developmentally disabled. It does happen, and sometimes it's permanent. And parents need to know that. They need to know something else, too, and that is vaccinations are not a one-size-cure-all. The big issue we've heard for this bill has been that the pertussis, which is whooping cough, has had a resurgence in Colorado. I've got a graph here. It's a pie chart, actually, on Colorado pertussis incidents from 2005 to 2011. It's the source is the Colorado Department of Public Health and Environment, CDPHE. They're the experts. And actually, I've got the chart here on the total cases, and among those total cases, those who were appropriately vaccinated. Do you know that among the a little over 1,005 cases that have been reported between 2005 and 2011 of pertussis, whooping cough in Colorado? See the blue part of this circle? 71% of those children were fully vaccinated who came down with whooping cough. Is that going to be part of the facts? I doubt it. I've never heard it presented from the proponents, and I believe we need all the facts on the table. As a consequence, I have an amendment. Because the bill, in its present form,
There is an amendment on the desk. Mr. Majors, please read L021.
Amendment L021, House Bill 12.
Thank you, Mr. Chair. I move L021.
To the amendment.
And the bill actually is two parts. One is to require schools to track and make public the vaccination rates for their schools, and I actually have no problem with that. I can see that that's part of that information that parents need. But the other half is the legislative declaration, which has not been touched so far. This is to add a sentence to the legislative declaration, and that is, quote, 71% of the children in Colorado who contracted pertussis were fully vaccinated. Now, those are the facts. And if we're going to fully inform the parents and the people of Colorado, I believe that that fact, most particularly with respect to vaccinations, should be clearly stated as well. So I urge the adoption of L021.
Senator Aguilar.
Thank you, Mr. Chair, and I'd ask for a no vote on L021. We have really changed this bill to just talking about getting parents education, and we're asking that the Department of Public Health and Environment develop an evidence-based educational system, and regardless of this fact, I mean, I could come up and pull out facts, including the fact that we had virtually eliminated measles until the year 2000 when we started seeing people who weren't vaccinated. And I don't really want this to become sort of a war around what facts we'd like in the legislative declaration. And I'd like us to trust our Department of Public Health and Environment, since we do ask them to put out information regarding risks and benefits. And I think what Senator Lundberg has brought forward is something that will be considered by them in their development of the scientific training, and I'd ask for a no vote.
Senator Lundberg.
Thank you, Mr. Chair. I respectfully disagree and would submit that if we really don't want to put the facts in the bill, let's get rid of the legislative declaration, because it's only one side of the facts. I still ask for an aye vote.
Is there any further discussion on L021? Seeing none, the motion before the body is the adoption of L021. All those in favor say aye. Aye. All those opposed, no. No. The noes have it, and L021 fails. Senator Lundberg.
Thank you, Mr. Chair. I have another amendment which I believe would be quite appropriate for the legislative declaration.
There is an amendment on the desk. Mr. Majors, please read L022.
Amendment L022 to House Bill 1288 by Senator Lundberg.
Thank you, Mr. Chair. I move L022. I'll read the pertinent parts. We'll skip this, strike the lines and add the lines, etc. Vaccination does carry some risk for the child receiving the vaccination, and parents should weigh the benefits and risks before choosing to have their child vaccinated. Now, that's the real point that we're trying to get across, is parents need to take the responsibility for having their children vaccinated. And this states the obvious, but I believe it should be stated, because if you're going to put out all of the one side of the argument, let's at least admit that there are two sides to the argument. That's all we're talking about here. I recommend an aye vote to L0 to the bill, Amendment L022.
Senator Aguilar.
Thank you, Mr. Chair, and I'm not opposed to this. I'd see this as a friendly amendment, and I support L022.
Is there any further discussion on L022? Seeing none, the motion before the body is the adoption of L022. All those in favor say aye. Aye. Those opposed, no. The ayes have it. L022 is adopted. To the bill. Seeing no further discussion, the motion before the body is the adoption of L0. A division has been requested on House Bill 1288. All those in the chamber who are not entitled to vote, please be seated. Sergeants, please call a division in the hall.
Let's wait a minute.
The motion before the body is the adoption of House Bill 1288 as amended. All those in favor, please stand. Please be seated. All those opposed, please stand. House Bill 1288 is adopted. Mr. Majors, please read the title to House Bill 1314.
House Bill 1314 by Representative Pedersen and Senator Kerr concerning cooperation between school districts and charter schools on ballot questions to authorize additional local revenues.
Senator Kerr.
Thank you, Mr. Chair. I move House Bill 1314, and I'm fairly certain there's no committee report this time.
You are correct. To the bill.
Thank you, Mr. Chair. This bill seeks to increase the cooperation between school districts and their charter schools and requires that districts include at least one charter representative on any mill levy planning committee they assemble, and that they invite each charter to participate in planning discussions concerning submission of a particular mill levy by no later than June 1st of the associated election year. I ask for an aye vote.
Is there any further discussion on House Bill 1314? Seeing none, the question before the body is the adoption of House Bill 1314. All those in favor say aye. Aye. Those opposed, no. The ayes have it. House Bill 1314 is adopted. Mr. Majors, please read the title to House Bill 1204.
House Bill 1204 by Representative Wilson and Senator Grantham concerning flexibility regarding the requirements imposed on rural school districts.
Senator Grantham.
Thank you, Mr. Chair. I move House Bill 1204.
To the bill.
Thank you, Mr. Chair. This was heard in Education Committee
colleagues, the gist of the bill is to just allow some more flexibility for our rural and small schools that are meeting their state achievement goals. The intent is to allow some of these successful rural and small schools the flexibility to maintain and enhance their excellent records that they have. As most of you are aware, the demands that are upon our school districts are pretty great when it comes to their reporting requirements, among many other things. There's a very exacting toll upon our administrators, on staff, and then ultimately that carries down to the students. What this will do is eliminate some of the reporting requirements for the rural schools that do maintain an excellent record, and it will change some of their reporting requirements from an annual reporting requirement to a biennial requirement, thus a very simple alleviation of a reporting requirement that currently exists, just to help them out and take some of the burden off of them every other year. And I would ask for an aye vote.
Is there any further discussion on House Bill 1204? Seeing none, the motion before the body is the adoption of House Bill 1204. All those in favor, please say aye.
Aye.
Those opposed, no. The ayes have it. House Bill 1204 is adopted. Majority Leader Heath.
Thank you, Mr. Chair. I move we rise and report.
You've heard the motion. All those in favor, please say aye. Those opposed, no. Committee will rise and report.
The Senate will come back to order. Senator Ulibarri.
Thank you, Madam President. The committee has met and considered a few bills. Mr. Majors, will you please read the report?
April 22nd, 2014, Madam President, your committee of the whole brings the reports out of consideration the following tax bills being second reading thereof makes following recommendations thereon. Senate Bill 186 as amended, Senate Bill 184 as amended, Senate Bill 185 as amended, Senate Bill 182 as amended, passes second reading in order and requires place to the counter for third reading and final passage. House Bill 1260 as amended, House Bill 1061, House Bill 1280 as amended, House Bill 1354, House Bill 1288 as amended, House Bill 1314, House Bill 1204, passes second reading in order to revise place to the counter for third reading and final passage. House Bill 1011 as amended, referred to the Committee on Appropriations, House Bill 1126 as amended, lost on second reading.
Senator Ulibarri.
Thank you, Madam President. I move for the adoption of the report.
Is there any discussion? There is. Mr. Minority Leader.
Thank you, Madam President. Request a roll call on 1288.
You can request a roll call on any part of the.
So we'll just do that.
We've done it. She's such a gooder. We'll talk to you.
I'll withdraw my name.
You're going to force. Mr. Minority Leader.
Because I think it's in the wrong spot. I withdraw my motion.
The question is the adoption of the Committee of the Whole report. Is there any discussion on the committee report? Oh, Mr. Majors, I cut you off before reading it. Mr. Majors, please read the report. Okay. Okay, the question is the adoption of the Committee of the Whole report. Any discussion? The motion is the adoption of the Committee of the Whole report. Are there any no votes? With 35 ayes, 0 noes, 0 absent, and 0 excused, the Committee of the Whole report is adopted. Senate Bill 186 is amended, Senate Bill 184 is amended, Senate Bill 185 is amended, Senate Bill 182 is amended, passed on second reading and ordered, engrossed, and placed on the calendar for third reading and final passage. House Bill 1260 is amended, House Bill 1061, House Bill 1280 is amended, House Bill 1354, House Bill 1288 is amended, House Bill 1314, House Bill 1204 passed on second reading and ordered, revised, and placed on the calendar for third reading and final passage. House Bill 1011 is amended, referred to the Committee on Appropriations. House Bill 1126 is amended, lost on second reading. Consideration of resolutions. Mr. Majors, would you please read the title to Senate Joint Resolution 10?
Senate Joint Resolution 10 by Senator Guzman and Representative Kagan concerning requesting the Chief Justice of the Colorado Supreme Court to take certain actions concerning adjudication of juvenile delinquency petitions.
Senator Guzman.
Thank you, Madam President. I move SJR 10, and I have an amendment. And shall I just go ahead? I'm not going to be, I'm not asking that it be read at length, but just if Mr. Majors could.
Okay, there is an amendment on the desk. Mr. Majors, would you please read L003?
Amendment L003, Senate Joint Resolution.
Senator Guzman.
Thank you, Madam President. And members, this resolution was a resolution that was designed several months ago, actually. It came from the interim committee on juvenile defense this past summer and fall. When this resolution was written and adopted at that time for introduction, there was a different Supreme Court justice, and since the new Supreme Court justice has arrived, we have met with her and have reworked some of the resolution to make sure that the judiciary is in support and affirms this resolution. So the amendment that I am presenting basically changes the name, strikes the name Chief Justice Michael Bender and substitutes Chief Justice Nancy E. Rice, and also strikes some paragraphs that the justice has already taken care of. And so actually the resolution reads, whereas actions by the judicial branch are necessary to address problems identified by the Juvenile Defense Attorney Interim Committee, and approve the juvenile justice system. Now therefore be it resolved that the General Assembly request the Chief Justice of the Colorado Supreme Court establish a committee of qualified persons to review the Colorado Rules of Juvenile Procedure, Juvenile Court Forms, and Chief Justice Directive 04-04, and make recommendations concerning any amendments to the rules, the forms, or the directive that may be necessary to improve the juvenile justice system. So basically, this is a resolution in support of the judiciary, as well as asking the judiciary to join with us and making opportunities within the judicial system to support juvenile representation and so forth. That is the resolution, and so I ask again for the adoption of SJR 10 and L003.
Thank you. Any discussion on L003? Are there any no votes on L003? With 35 ayes, 0 noes, 0 absent, 0 excused, L003 is adopted. Any further discussion on Senate Joint Resolution 10? Seeing none, the question is its adoption. Are there any no votes? With 35 ayes, 0 noes, 0 absent, 0 excused, Senate Joint Resolution 10 is adopted. Co-sponsors: Senator Ulibarri, Senator Aguilar, Senator Kafalis. Please add the Majority Leader. Mr. Majors, would you please read the title to House Joint Resolution 1009?
House Joint Resolution 1009 by Representative Williams and Senator Ulibarri concerning a request that Congress restore the Federal Voting Rights Act of 1965 as amended.
Mr. Majority Leader.
Thank you, Madam President. I move we lay over House Joint Resolution 1009 until tomorrow, Wednesday, the 23rd.
For the motion, all in favor say aye.
Aye.
Opposed, no. Ayes have it. We will lay over House Joint Resolution 1009 until tomorrow. Mr. Majors, would you please read the title to House Joint Resolution 1014?
House Joint Resolution 1014 by Representative Sonnenberg and Senator Brophy concerning the designation of March 26, 2014 as Agriculture Day in Colorado.
Senator Brophy.
Thank you, Madam President. I move House Joint Resolution 1014. This was supposed to be heard on March 26th, but 65 prima donnas spent entirely too much time talking about it, and we ended up breaking for lunch. And so I'm asking for you today to support the adoption of the designation of March 26th as Agriculture Day in Colorado, and ask for an aye vote on House Joint Resolution 1014.
Any discussion? Senator Balmer.
Thank you. Thank you, Madam Chairman. Just a quick question for the sponsor. What specific time of the day will it start? Will this be daylight savings time or general time or Brophy time?
You get your own time zone, Senator Brophy. Senator Brophy.
Well, we all know that agriculture starts when the sun rises. It doesn't matter what the clock says. So the answer is when the sun comes up and the roosters are crowing, we're going to work.
Senator Lambert.
Thank you, Madam President. I make an alternate motion to lay this over until March 26th.
Any further discussion? Okay. Question is the adoption of House Joint Resolution 1014. Are there any no votes? With 35 ayes, 0 noes, 0 absent, 0 excused, House Joint Resolution 1014 is adopted. Senator Brophy.
Thank you, Madam President. I would ask that the current roll call be added as co-sponsors.
Request has been made to add the morning roll call as co-sponsors. Is there any objection? Seeing none, the morning roll call will be added as co-sponsors to House Joint Resolution 1014. Consideration of House amendments to Senate bills. Mr. Mr. Majors, would you please read the title to Senate Bill 30?
Senate Bill 30 by Senator Crowder and Representative Wilson concerning the fee charged to issue a special license plate to a person with a distinguished flying cross that was awarded for valor and in connection therewith making an appropriation.
Senator Crowder.
Thank you, Madam President. I move Senate Bill 14030.
Would you like to move that the Senate concur with House amendments to Senate Bill 30?
Madam President, I would like to move that I concur with this House amendment.
Okay. Senator Crowder, please proceed to explain what the House did to your Senate Bill 30.
Thank you, Madam President. What this is basically a technical amendment. What it does is add a small amount to appropriations due to the fact that OIC or the to obtain computer issues to make this bill workable, and that's all it is. And with that, Madam President, I do concur.
Any discussion on the motion to concur? Seeing none, the question is for the Senate to concur with House amendments to Senate Bill 30. Are there any no votes? With 35 ayes, 0 noes, 0 absent, 0 excused, the Senate concurs with House amendments to Senate Bill 30. Senator Crowder, would you like to move for readoption of your bill?
Thank you, Madam President. I move for readoption of Senate Bill 14030.
Any discussion? Question is the readoption of Senate Bill 30. Are there any no votes? With 35 ayes, 0 noes, 0 absent, 0 excused, Senate Bill 30 is readopted. Additional co-sponsors. Senator Roberts. Mr. Majors, would you please read the title to Senate Bill 36?
Senate Bill 36 by Senator Baumgartner and Representative Garcia concerning the creation of an emergency medical services license plate for motor vehicles and in connection therewith making an appropriation.
Senator Baumgartner.
Thank you, Madam Chair. I move that we concur with House amendment to Senate Bill 36.
That is a proper motion. Please explain what the House did.
They actually removed a phrase or a sentence on page 4, line 22, Information Technology Division, because that no longer exists due to reorganization in Department of Revenue.
Any discussion on the motion to concur? Question is for the Senate to concur with House amendments to Senate Bill 36. Are there any no votes? With 35 ayes, 0 noes, 0 absent, 0 excused, the Senate concurs with House amendments to Senate Bill 36. Additional co-sponsor. Senator Baumgartner.
Thank you, Madam President. I move that for the repassage of Senate Bill 36.
Any discussion? Question is repassage of Senate Bill 36. Are there any no votes? Senator Stedman. Senator Hodge. With 33 ayes, 2 noes, 0 absent, and 0 excused, Senate Bill 36 is readopted. Additional co-sponsors. Senator Rivera, we've got you. Mr. Majors, would you please read the title to Senate Bill 41?
Senate Bill 41 by Senator Herpin and Representatives Gardner and Swallen concerning the creation of a USS Colorado license plate for motor vehicles and in connection therewith making an appropriation.
Senator Herpin.
Thank you, Madam President. I move the Senate concur with the House amendments to Senate Bill 14041.
Thank you. Please proceed with your explanation.
Thank you, Madam President. The Senate Appropriations Committee added in $4,120 for allocation to the Office of Information Technology for the Division of Computer Center Services to implement this license plate. The House Appropriations Committee struck for allocation to the Office of Information Technology.
Any discussion on the motion? Seeing none, the motion is for the Senate to concur with House amendments to Senate Bill 41. Are there any no votes? With 35 ayes, 0 noes, 0 absent, 0 excused, the Senate concurs with House amendments to Senate Bill 41. Senator Herpin.
Thank you, Madam President. I move for the readoption of Senate Bill 14041.
Any discussion? Question is readoption of Senate Bill 41. Are there any no votes? Senators Hodge and Stedman. With 33 ayes, 2 noes, 0 absent, 0 excused, Senate Bill 41 is readopted. Mr. Majors, would you please read the title to Senate Bill 161? Oops, rewind. Co-sponsors on Senate Bill 41 that haven't already. Senator Crowder, we've got you. Senator Todd, we've got you. Okay, Mr. Majors, would you please read the title to Senate Bill 161?
Senate Bill 161 by Senators Ulibarri and Johnston and Representative Hollinghorst, concerning the modernization of provisions of the Uniform Election Code of 1992 that ensure voter access for eligible electors, and in connection therewith reducing the deadline by which a voter registration application must be submitted via certain methods, altering procedures pertaining to national change of address searches, allowing emergency ballots to be obtained for non-medical reasons, amending provisions relating to military and overseas voters, increasing the penalty for providing false residential information, making the aiding or abetting of the provision of false residential information new felony offense, and making and reducing appropriations.
Senator Johnston.
Thank you, Madam President. We move that the Senate concur with House amendments to Senate Bill 161.
Please proceed with your explanation.
Thank you, Madam President.
Senator Ulibarri.
There were 2 amendments adopted in the House. One is to clarify that if a voter has already cast a ballot in an election and submits an application after casting the ballot to register again, the county clerk and recorder shall defer processing that voter's application until after the close of the election. And the second indicates that the clerk and recorder must provide or shall provide training in the technique and standards of signature comparison to election judges who compare signatures pursuant to the section, and then renumbered all of the sections after that accordingly.
The question is for the Senate to concur with House amendments to Senate Bill 161. Is there any discussion? Question is for the Senate to concur. Are there any no votes? With 35 ayes, 0 noes, 0 absent, 0 excused, the Senate concurs with House amendments to Senate Bill 161. Senator Johnston.
Thank you, Madam President. I move that the Senate readopt Senate Bill 161.
Any discussion? Question is the readoption of Senate Bill 161. Are there any no votes? Senators Lambert, Baumgartner, I think Crowder. When your hands are like this, I can't tell. Senator Shuffle, Senator Crowder, Mr. Minority Leader, Senators Renfro, Grantham, Marble, Lundberg, Herpin, Brophy, Hill, Balmer, Harvey. With 21 ayes, 14 noes, 0 absent, 0 excused, Senate Bill 161 is readopted. Additional co-sponsors. Sarah Heath, we've got you. Okay, Mr. Majority Leader.
Thank you, Madam President. I move to reconsider Senate Bill 30, a license plate bill. We had 2 of our members fall asleep and need to change their vote.
Question is reconsideration of Senate Bill 30. All in favor say aye. Opposed, no? Ayes have it. The Senate will reconsider Senate Bill 30. Mr. Majors, would you please read the title to Senate Bill 30?
Senate Bill 30 by Senator Crowder and Representative Wilson, concerning the fee charged to the issue of special license plate to a person with a distinguished flying cross that was awarded for valor in connection therewith making an appropriation.
Senator Crowder.
Thank you, Madam President. I
move we concur.
I move we concur 14030.
Question is for the Senate to concur with House amendments to Senate Bill 30 that were previously explained. Any discussion? Any no votes on concurrence? With 35 ayes, 0 noes, 0 absent, and 0 excused, the Senate concurs with House amendments to Senate Bill 30. Senator Crowder.
I move to readopt Senate Bill 14030 and place everyone on the concurrent roll.
Question is the readoption of Senate Bill 30. Are there no votes? Senators Stedman and Hodge. And John. That'll do it. We'll check for co-sponsors one more time. You haven't already co-sponsored Senate Bill 30. Now is your time. Okay. So the vote count on readoption was 32-3. 32 ayes, 3 noes, 0 absent, 0 excused. All right.
Yes.
Mr. Majority Leader.
Thank you, Madam President. I move we lay over Senate Joint Resolution 27 until Friday, April 25th.
You've heard the motion. All in favor, say aye.
Aye.
Opposed, no. Ayes have it. We will lay over Senate Joint Resolution 27 until Friday. Message from the House.
April 22nd, 2014, Madam President, the House has passed a third reading, transmitted the advisory statutes, House Bill 1362. The House has passed a third reading, returns it with Senate Bills 92 and 49. April 22nd, 2014, Madam President, the House has adopted and returns it with Senate Joint Resolution 26 as amended. The House has voted concurrent Senate amendments to House Bills 1017, 1290, 1345, 1006, 1042, 1045, and 1207, and has repassed the bills as so amended.
Message from the Reviser.
April 22nd, 2014, we hear with transmit without comment, House Bill 1362.
Introduction of bills.
Senate Bill 209 by Senators Heath and Sheffield and Representative Tyler concerning the requirements for permissible investments by insurers and loans secured by interests in real estate.
Business, Labor, and Technology.
Senate Bill 210 by Senators Cadman and Aguilar and Representatives Sonnenberg and Kraftharp concerning the conduct of examinations of insurers by the Commissioner of Insurance and in connection therewith requiring a pre-examination conference and a conference to be held before issuance of a draft examination report.
State Veterans and Military Affairs.
House Bill 1350 by Representative Ferrandino and Senator Kerr concerning modifications to the criteria for regional tourism projects approved by the Colorado Economic Development Commission through the Colorado Regional Tourism Act and in connection therewith making and reducing appropriations.
Finance.
House Bill 1362 by Representative Moreno and Senator Ulibarri concerning great-grandparent visitation with great-grandchildren.
Judiciary. Announcements. Senator Newell.
Thank you, Madam President. Members, I have two quick announcements. One is the MS Walk is Saturday, May 3rd. You are going to love fresh air in the morning and free pancakes and breakfast goodies and all of that. We have the Capitol Crew every year that I've been here since 2009. And this year I am walking for myself. So I ask for your support in both donations and in walking, and would love to have you join us. If you are interested in being in the Capitol Crew and having a Capitol Crew t-shirt, then we can have those made for you as well. So please let me know about that. And all of your staff and interns are invited as well. And then my second announcement is that tomorrow is a Colorado Denim Day, which is, for those of you who don't know, Denim Day is a worldwide movement that started in 1997, and rather than going through the whole story today, just let you know that if you come tomorrow in denim of any kind and donate, even if it's a penny, but we'd love to have more, this goes to sex assault victims and survivors. And so we ask that for your support. You may wear denim tomorrow. I will bring the donation things tomorrow and would love to have your support. Thank you.
Senator Todd.
Thank you, Madam President. And just a change in order for Transportation Committee this afternoon. We will hear Senate Bill 200 first, and then House Bill 1029 and Senate Bill 197. So Senate Bill 200 will go first in Transportation this afternoon. Thank you.
Senator Hodge.
Thank you, Madam President. This is just a notice for people in appropriations. We have added House Bill 1011 for tomorrow's calendar.
Mr. Majority Leader.
Thank you, Madam President. Colleagues, thank you for your cooperation today. I'm going to move, we recess again because of we're going to be reading things over from the House, and we'll continue that rather than adjourning. So with that, Madam President, I move that the Senate recess until 1 p.m. today, Tuesday, April 22nd.
You've heard the motion. All in favor say aye.
Aye.
Opposed, no. Ayes have it. The Senate will stand in recess till 1 p.m. today.